Good morning, afternoon, evening, whenever you're watching this. Not legal advice. Please like, subscribe, share, comment. Going to talk a little bit about, briefly, the litigation involving Elon Musk's pay package involving Tesla and the ongoing litigation. But before I start, of course, as I do, three things I wanted to talk about. Today I'm going to focus on lawyers because that's what we're talking about. What's the difference between a lawyer and God? God doesn't think he's a lawyer. What's the difference between a lawyer and a liar? Pronunciation. And last but not least, what do you call a lawyer who does not chase ambulances? Retired. Now, obviously, not all lawyers are like that, but just for fun. So, the ongoing action in Delaware involves a challenge to the pay package that was provided to Elon Musk in 2018. Cases was handled there in front of Judge McCormick. She ruled there was a breach of fiduciary duty and that the affirmation by the shareholders was not proper due to a lack of full disclosure, etc. So there is now a proceeding ongoing to conclude that litigation where attorney's fees are being calculated. And in essence, in this case, in my opinion, of course, not legal advice, this case is only about legal fees from the start. And because the only beneficiary of this action, in my opinion, are the lawyers. The shareholders of Tesla certainly don't benefit. The individual plaintiff, who only had 9 shares, I believe, does get some bonus, but that does not reflect all shareholders, just somebody who was chosen, who has apparently done this in the past, and probably gets something like a $10,000 or $15,000 bonus on top of the 9 shares he owes, but nothing beyond that. Tesla shareholders receive nothing directly. The only one who would receive anything directly would be the lawyers. So there's ongoing litigation over the attorney's fees. And the way that works is a motion is filed, and the party seeking fees tries to demonstrate why they're entitled to attorney's fees. That motion has been filed. They sought, as opposed to money, which is interesting, they sought stock, and it was approximately, I think, 29 million shares, which at that time equated to approximately, I'm using approximate numbers, $6 billion, which would be I believe, by far the largest attorney's fee award ever issued, period. So that has now been responded to with a couple of oppositions or objections. One was done by a Tesla shareholder named Amy, very, very smart person who hired Munger, Tolles, and Olson along with another party to handle them. Munger, Tolles, and Olson is one of the top-rated firms in the United States. Charlie Munger of Warren Buffett fame was one of the founding partners of that. Anyway, they're involved, and they've filed a brief objection to the attorney's fee award. And I think yesterday or the day before, Tesla filed an objection or opposition to the attorney's fee award. There's a bunch of other defendants who are named, including Elon, who have not yet filed, or the documents have not been placed on the judicial site yet. And they can file. They don't have to, but they can. I would expect additional filings to be made. So the way this comes about and the dispute in terms of what attorney's fees should be awarded, in Delaware, the law basically is you look for the benefit that's conferred. You use the lodestar method, which I will explain, as a way of deciding if there's any windfall, because Delaware courts do not prevent windfall awards to attorneys. At least that's the proposition. As a matter of fact, Judge McCormick said, I think in 2022 or 2023, that attorneys won't get windfalls unless they provide a substantial benefit to shareholders directly. So the attorneys for Toretta, who's the plaintiff, claim that they're entitled to that fee award, and they're doing a favor to Tesla by not taking the money directly because of the benefit they conferred. And that benefit would be $55.1 billion, which takes into account the options that were not exercised by Elon Musk. But if they were, they claim at that time they were worth $55 billion. The options themselves, when they were valued by Tesla in, I think, 2018 were worth approximately $2.3 billion, although there was no exchange of money. So the attorneys for the plaintiffs claim there's a benefit of $55.1 billion, although that money does not flow into Tesla, shares are not returned to Tesla, etc. It's just about not being able to exercise the options that, again, were valued at $2.3 billion back in 2018. So their argument is they're entitled to a percentage of that $55.1 billion. There was a case in 2022 involving Dell Computers in which there was a settlement of $1 billion and the attorneys got 26.6%. So these attorneys are seeking less than that theoretically. They're only seeking about 10 or 11%. That's their argument. So they provided a big benefit because they canceled the options. That's what they say the big benefit is. In essence, nothing has come to the shareholders. And if their award is granted, actually shares will be removed. And in effect, there'll be dilution across the board for all Tesla shareholders. So I find that hard to understand how that's a benefit to Tesla shareholders, but that's their argument. So the flip side, when we have two objections, two oppositions filed so far, is one, that benefit argument is nonsense because there's no benefit conferred. One, because there was no stock issued. And two, there's no benefit of $55 billion. And three, if there is any benefit, you want to value it, it's the return of those unexercised options. And that would start at $2.3 billion. And there would be reductions based upon, because you would make adjustments to those figures. And after those adjustments, then there would be a percentage that would be awarded. And obviously that amount would be substantially less than, probably less than $100 million if you do the calculation. So the argument by the two parties have filed objections or opposition so far is one, there's no benefit conferred, so you shouldn't use that formula. Two, that the proper way of looking at this would be looking kind of in the lodestar method. That's what's used here in California. And that's basically what you do is you take the number of hours worked, which would, in this case, I think it was approximately 19,000 claimed, times the hourly rate of someone with your experience in your jurisdiction, and you do a multiplication. That gives you a number. And if there have to be adjustments because the case was difficult, because you spent more time, because it was late in the case, or any other factors, you can add a multiplier to that. And historically speaking, because this is in the papers, the multiplier is somewhere between 1.3 to 3.7. So if you got an award of, let's say, $10 million, and you use that 3.7 multiplier, that would bring you to $37 million. That's kind of how it would work. But lodestar is not used specifically in Delaware. It's only used as a measure of making sure that the attorneys don't get a windfall. So you might make a calculation, and then you'd use lodestar, hours times rate, to see if the amount that you've provided is way above what the lodestar method would give you. And if it was way above, then you would characterize that fee as a windfall, and it would be inappropriate. But lodestar itself is not a method used specifically in Delaware. So because there's no way of calculating the actual benefit, and there really is not, because there is no money flowing, like in the Dell case I mentioned, there was actually $1 billion cash flowing from Dell, from flowing to the shareholders in essence. So from there, you could actually calculate a benefit. And in other cases, there may be monetary relief that are afforded or other things. But here we have, seems pretty speculative in terms of what the relief is, and the relief cannot be speculative. So as a result, it would be tough to use the method, the conferred benefit method. So what are you left with? Well, what you're left with is a theory called quantum merit, which means that if there's no real contract in force, but you've performed services, you're entitled to the reasonable value of your services. So even if you disagree, and obviously Tesla doesn't agree, or Elon doesn't agree with the result, and that result may be appealed in and of itself, but if you're trying to calculate a fee based upon the award, which you have to do to get to a final judgment from which you can appeal, what they're indicating, and in both oppositions I've seen, or both objections, quantum merit was the conclusion, the reasonable value of services. So how do you determine the reasonable value of services? In effect, you kind of use the lodestar method, and you figure out the number of hours times the rate, and that kind of gives you a reasonable value of services. So even if it's not called lodestar, quantum merit might bring you very close to that. So in both objections, oppositions, they say if you kind of look at that, and if you add a multiplier, and the highest multiplier is 3.7, I think they found, their expert found, you'd be in the range of approximately 40 million. In the Tesla objection, they agree lodestar, which means the number of hours times the rate, would yield about $13 million. That's what they say should be awarded. But they also indicated if you do a multiplier, because it's a tougher case, because it's late in the case, because of any special reason, the maximum that multiplier should be would be 4, which would bring you to about 50 million in legal fees. Now, $50 million in legal fees is a huge number, but it's a lot smaller than 6 billion in stock. And according to that calculation, the 6 billion in stock, that would give you an hourly fee of approximately $288,000 per hour worked, which is, even for me, would be a high rate. So there will probably be additional oppositions and objections that are filed. There will be a reply that will be filed by the attorneys for plaintiff. And then there's a scheduled hearing as of now, July 8th. That could change, but that's what's scheduled. Court will issue a ruling probably within 30 days. After that, then we'll get a final judgment. Then appeals can start after that. So again, the difference is, and where we are at, ongoing dispute as to the attorney fees award. Plaintiff wants the benefit conferred. They define the benefit as the 55 billion, all the stock that would have been issued that hasn't been issued. And the objection to that, and I think a well-founded objection, is it should be the reasonable value of services, or using the lodestar method, look at the amount of time times the hours. If it's a tough case or a late case, make an adjustment, but that would come in somewhere between, let's say, 13 and $50 million. So quite a wide gap, 13 to 50 versus 5 billion. It'd be interesting to see what the judge rules. I think the judge is more likely, if the judge wants the result sustained, upheld, in other words, she will need to find in the lower range, because I think if she finds in the upper range, there's going to be no support. There'll be limited support for that, because it'll be determined that it's too speculative to figure out what the benefit conferred is, and that a reasonable value of services based upon time and the hourly rate is a much better and much more efficient way of doing that. This is an ongoing dispute. We'll get additional documents. I'll comment on it as I see it, if there's change or interesting arguments that relate to this, and I'll certainly comment on the reply brief and the result. Anyway, hope that clarifies where we're at and what the issues are. Be well, have a great weekend, take care, and